Judge Torres believes it is sufficient and fair to extend the XRP litigation. In order to keep the public from accessing discovery materials related to Ripple remedies, the U.S. Securities and Exchange Commission and Ripple Labs have filed a lawsuit in federal court. These records include thorough financial statements and XRP institutional sales that happened after the complaint was filed. A federal judge has approved updates to the timeline and redactions made to the document about remedies. According to a court filing dated March 20th, Judge Annalisa Torres approved an order addressing sealing concerns regarding the upcoming remedies-related briefing in response to a joint application by Ripple Labs and the SEC to resolve the parties' disputes. According to Cunning T's reporting, Torres believed it was appropriate to extend the XRP litigation according to the new dates. The attorneys representing the plaintiffs and defendants hope that the plan will enable the swift and public release of the parties' pleadings, albeit with some redactions that will keep significant sales hidden from the XRP army and the cryptocurrency community, as Ripple Judge Torres' decision that XRP was not a security analyst ended the litigation, but the SEC and other parties are continuing focusing on XRP sales in the wake of the complaint. An element that may impact the price of XRP is the ongoing litigation between the SEC and Ripple Labs, which is also being handled by us. Judge Torres may evaluate and rule on the Securities and Exchange Commission's SEC assertions regarding the penalty for XRP sales to large investors following a complaint, provided that the attorney's predictions come true. In the event that Ripple and the SEC reach a settlement, the case will continue for several more months until Judge Torres renders her final decision, which is anticipated to happen early in the following year. Similarly, on July 13, 2023, Judge Torres took longer to render a summary judgment. Judge Torres determined what constitutes fair detailed financial statements and post-complaint disclosures. Examples of these disclosures are the discovery materials that the U.S. Securities and Exchange Commission and Riverside Labs have filed in federal court to keep records pertaining to the XRP lawsuit extension and Ripple's remedies from being accessible to the public. A federal judge mandated that the updated timeline and redactions be included in the remedy-related filing. Judge Torres has given the order to seal the remedy-related briefing. Judge Annalisa Torres issued the order to rule on sealing issues connected to the forthcoming remedies-related briefing on a joint application filed by Ripple Labs and the SEC. According to a March 20th court document, Torres thought that the parties' disagreements may be fairly resolved by using the new dates for the XRP case extension. According to Cohen Jeep, the attorneys for the defendants and plaintiffs concur that the plan would provide prompt public access to both sides' papers, subject to some redactions. The cryptocurrency community and the XRP army are probably going to be kept in the dark about important issues until Ripple, the SA, and other third parties work out the necessary redaction. Even while experts see little merit in the case, the focus is still mostly on XRP sales following Judge Torres' ruling that XRP is not a security. On March 22nd, the Securities and Exchange Commission submitted the opening brief pertaining to remedies, along with any further declarations and exhibits, under seal. On March 6th, the Supreme Court made available to the public a redacted version of the brief that had been requested by both parties and third parties. As a result, Ripple and the SEC have set new dates for the litigation. It looks that the debate and fight will continue past May 6th. The length of the statute would be further prolonged if the SEC raised objections to Ripple and other unexpected submissions in accordance with Section 5 of the U.S. Securities Act. Judge Torres can also consider an order on the SEC's allegations concerning the penalty for XRP institutional investor sales made after the complaint was filed if the anticipated settlement deal between Ripple and the SEC cannot be reached. Ripple will submit a redacted version of its opposition brief along with supporting evidence on May 6th, and the SEC will file its sealed response brief. Torres seeks an additional summary judgment on July 13, 2023, declaring that XRP is not a security. Since neither Ripple Labs nor the U.S. Securities and Exchange Commission are requesting the public disclosure of material information regarding remedies, this is a significant development in the ongoing dispute between the two organizations. According to the most recent court filing, Ripple Labs and the U.S. Securities and Exchange Commission have jointly moved to seal important information contained within the remedies-related briefing. Both the plaintiffs and the defendants' attorneys have urged Judge Torres to greenlight the plan, arguing that it will ensure the public's rapid access to the Perry brief, notwithstanding specific redactions, because the outcome and conclusion date of the protracted case between Ripple Labs and the SEC. The Securities and Exchange Commission submitted the opening remedies-related brief under seal on March 22, 25, along with any supplemental declarations or exhibits. In response to the market sentiment expressed in response to the SEC's opening brief on remedies, which was due on May 6, the parties have proposed a timeline for redaction. A meeting is scheduled to discuss the redactions in order to identify them after the parties and third parties have requested them. Redacted versions of the brief and the opposition brief from Ripple were made public by the SEC on March 26. The deadline for submitting this documentation is April 22. The parties are expected to meet in the coming days to submit a revised reply brief. The deadline for the parties and any intervening third parties to file written motions opposing depositions about the ceasing of filing details is May 20th. As a result, the litigation is expected to last for several more months, with a final verdict likely to be rendered sometime in May of the following year. In the meantime, the cryptocurrency market as a whole has declined from its recent highs. According to market capitalization, the token powering the 7th largest cryptocurrency ecosystem is priced at XRP. The price of Ethereum also dropped sharply from almost $4,000 to $3,500, a 15% decline. XRP fell sharply from 74 cents, its all-time high in 2024. The XRP price has remained steady at 58 cents. Given that more and more deadlines are approaching for both Ripple and SEC, the trend may still be continuing. Price forecasts have been made on the price of XRP. Given that both parties have important deadlines coming up, there may be an influence from Ripple and the Securities and Exchange Commission. The Securities and Exchange Commissions, as well as XRP, may be impacted by a U.S. regulator's efforts to protect confidential information and prevent its disclosure to other parties. The legal documents will stay sealed until April 24th, at which time they will become publicly available. Legal experts have emphasized the crucial significance of these actions, and the SEC has until May 7th to present its case. Additionally, some of the content will be available to the public beginning in May. That's all for now.